Well, thank you very much. It's great to be with you today. Just doing a bit of an update around public policy and advocacy. And the reality is, the last couple of years, particularly before I finished up in the employed role with ACS, was very busy because there was so much happening. We were involved in the town hall events in response to what was happening with the ALRC report, as well as involved in a lot of advocacy here in Queensland around the Anti-Discrimination Act and the review into that and the changes there. And so things were really busy and it was a pretty pressured time, but a lot of that has come off the ball with the change of government here in Queensland and the decision to pause the Anti-Discrimination Act review and changes, which has been certainly welcomed by many of us within the Christian schooling sector. And then also the decision not to progress with the ALRC report recommendations at this point in time. And so whilst we're waiting to see what happens with the new government at the Commonwealth level, at least at this stage, things are a little bit quieter than they've been over that last couple of years. But it was certainly a very exciting period to be involved in. So today what I wanted to instead focus on, rather than looking at those areas which we were mainly addressing over that period, is really just addressing what are some of the other more subtle changes that have been made over the last 6 to 12 months and that are coming in over the next 6 months, which will have an impact more generally on your school and what you might need to be thinking about in response to it. It's not so much about faith issues as it is more about just general education responsibilities, care and welfare of students, and also safeguarding of information. So the issues that I looked at when I wanted to address this was child protection and what's happening in that space, and particularly around the reportable conduct scheme, which is now being brought in on a bit of a fast track approach, just been announced in the last couple of weeks. There's also been some changes around sexual harassment here in Queensland, which is worth being aware of as to how that's going to impact upon you. And then also we're seeing quite a bit coming out of the National Redress Scheme and approaches that they're making to schools in particular to join the National Redress Scheme. A lot of schools have been able to fly under the radar there, but no longer are able to. And then I want to finish up with privacy and cybersecurity, as we've seen some of the things that have happened within the general community around cybersecurity and what you as a school need to be thinking about to protect yourself in those spaces. So let's start first then with child protection. And when I talk about child protection, I want to focus on initially the student-on-student area of child protection. Over the last 3 months particularly, we've seen a real uptick in media interest in this space. We've had the Courier Mail campaign by Kylie Lane, which has really focused in on Lutheran Education Queensland and a number of Lutheran schools here, but they've also been looking at other private schools within Queensland and asking how are those private schools responding to student-on-student sexual abuse and sexual bullying and the like. And what we saw coming out of that campaign is some fairly strong words from the Premier and the Minister for Education saying that schools have to be doing more in this space. Now, it's interesting because early this morning we heard from one of the sponsors talk about the fact that you can no longer say that what happens within the home environment or outside of the school premises is not something for you to be concerned about. And certainly the expectation from government and from media is that actually you do need to be concerned about what's happening outside of the school context, because it brings itself back into the school context. It brings those relationships, those broken relationships, back into the school. And so the expectation from media and from government is that schools need to be taking strong action around these student-on-student sexual abuse matters. So what are some of the things that I find interesting here is the fact that one of the things that the media are really honing in on is how schools are responding when complaints are received. And particularly they're asking the question, have you made the appropriate reports to the police? And it wasn't that long ago that schools would say, well, the student-on-student issues weren't really being captured by the mandatory reporting provisions, so we weren't reporting those to police. But when you go back and you look at those mandatory reporting provisions, you can see that there certainly is an obligation to report to the police. But more concerningly, the media are actually going to the police and asking them, has the allegation been reported? And the police seem to be quite happy to share whether it has been reported or not. And that's been some of the factors that have come out in some of the media reporting. And then when if a complaint is then made to the regulator, to NASAD, they will also be asking the question, how have you reported, how have you followed your reporting obligations? So one of the key things you need to be aware of is making sure that you're making very adequate, prompt reporting to the police, to child safety as needed, to be able to demonstrate that you complied with that. And the other thing is to understand that just because something is happening outside of the school premises doesn't mean that the school is not entitled to respond to it. And that then asks the question, have you reviewed your code of conduct to ensure that it does actually talk about expectations of students outside of the school context? Does it talk about behaviour expectations? Do you talk about not bringing the school into disrepute, not causing harm to other students, and then being able to act upon that if it is raised with you? Bearing in mind that ultimately your primary reason for acting is duty of care to all of your students, and particularly those students who might be being harmed as a result of this behaviour. And so there's that expectation that you act, you respond promptly, and certainly again the regulators are expecting that you're taking that type of prompt action. The other thing that we've seen also in the child safe area is the Child Safe Organisations Act, which came was passed by the Queensland Parliament late last year, and establishing the Queensland Family and Child Commission. Now, that was initially set up to have quite a long staged approach. Initially, it was going to bring in the 10 child safe standards, which came out of the Royal Commission, and that most churches would have already been implementing, but schools have been slower to adopt because they've got their own policies that they will pick up, which align with state legislation. But now there's an expectation that all entities working with children will adopt the 10 child safe standards, and the initial program for adopting that was for 1 January 2026 for those to be adopted by the early childhood sector, and then 1 April next year for religious bodies, and then schools would follow after that. And so we have this delayed period, but it's important that you are reviewing your child safe policies now in order to bring them into compliance with the child safe standards. And I know that NASAD have written to all the governing bodies about that and given a very helpful time frame as to how that needs to be followed. But that's just one thing to be aware of, and it is something that is coming under increasing scrutiny from NASAD. More importantly, however, is the reportable conduct scheme, which was also a recommendation out of the Royal Commission, but it wasn't really picked up here in Queensland. It was picked up in New South Wales fairly quickly after the Royal Commission, but Queensland took a lot longer to adopt it. Essentially, the reportable conduct scheme is, I like to think of it as a scheme that mirrors the current Queensland College of Teachers reporting scheme that you have for registered teachers. So it doesn't replace that scheme, but it basically extends it to all workers and volunteers within the school, and a requirement to report to the Queensland Family and Child Commission around any complaints that are received and how you then deal with those complaints, how you've investigated those, and to then take the Commission on the journey with you as you do your investigation and report back to them. So the reportable conduct scheme was initially down to commence for education in 1 January 2027, and then 1 July 2027 for religious bodies and early childhood. Had quite a long lead time, and that was intended because organisations would need to fund their preparation for that. In fact, they were saying that for religious bodies, for example, it would essentially be the funding of a full-time role for a religious body to be carrying out this role, to be carrying out these investigations and reporting. Coming out of what's happened down in Victoria with the early childhood, we've now seen the Queensland Government announce that in the early childhood sector, that's now going to be fast-tracked to 1 July 2026. So for those schools that are operating early childhood centres, you will need to be complying with the reportable conduct scheme from mid-next year. and making those reports about any allegations or complaints that are received to the Commission from that date. So it's just something to be aware of. Again, child protection is a key issue as we're moving forward. The other area that I thought was also quite interesting was around sexual harassment. Late last year, the Queensland Government passed, just before the election, the Respect at Work Bill. And one of the other things that they passed, though, which went under the radar, was the Work Health and Safety Sexual Harassment Amendment Regulation. And what this required employers to do is to take even more active steps in relation to the management of sexual harassment within your workplace and also gender-based harassment within your workplace. Up until this point in time, all employers still had an obligation to manage psychosocial risks and implement control measures to manage those risks, particularly around bullying, for example, and other conduct that might injure a person's psychological well-being. But then from 1 September 2024, the government introduced a requirement for all employers to proactively manage the risk of sexual harassment within their workplace. Then in March this year, they introduced a further requirement that really hasn't gotten a lot of attention yet by employers, and that requires employers to have where they have identified a risk of sexual harassment or gender-based harassment, they must then go on and implement a sexual harassment prevention plan to protect workers. Now, the reality is that every school will have a risk of sexual harassment or gender-based harassment, whether that's a staff-on-staff risk or whether that's a student-on-staff risk. Every school is going to have that as a reasonable risk. And so what that means is that every school has to put in place a prevention plan in how they're going to manage that risk. And it's actually a penalty provision to not have this prevention plan in place. Now, the key thing to note is that this prevention plan needs to be developed in consultation with your staff. So you can't just go and take a prevention plan off the shelf and use that. And the reason for that is that staff have to be involved in identifying what are the particular risks within your workplace and how are those risks going to be best managed within the workplace. So you're taking staff along the journey with you in developing the prevention plan. And I don't see that as something that's really happening yet within schools, and it's something that you do need to start to address. So what is this prevention plan? Well, first of all, it needs to be in writing, so you're actually preparing it in writing, you're signing off on it, and if the regulator asks for it, that's the WorkCover Queensland, the Work Health and Safety Office asks for it, you need to give them a copy of it. It also needs to go on to state each identified risk that you've identified within your particular workplace. Now, the plan that is available on the website that the government puts out as part of their training, for example, talks about within a retail shop environment, and it talks about a risk being taking the rubbish out at night and a staff member potentially being at risk of harm when they're taking the rubbish out at night. So how is that risk going to be managed? And the consultation process with staff about how they're going to manage that risk. They're the types of risks that you have to have in mind within your school community to say, what are the risks and how are we going to manage it? What are the control measures that we will be implementing? You also need to go on and describe within the plan how you've gone about your consultation process, how that's actually occurred. It then needs to set out the process for dealing with reports of harassment, and you'll draw that from your sexual harassment policies. It needs to be expressed in a way that's readily accessible and understandable to workers. That's probably not so much of an issue within a school-based area as it is within retail, for example, or working with people that don't have a clear understanding of English, but still it needs to be readily understandable, readily accessible and able to be implemented. And then finally, it needs to be reviewed, and it doesn't just need to be reviewed every 3 years, that's the minimum review, but you also need to review it after any complaint of sexual harassment or gender-based harassment. So there's that ongoing review process. If you receive a complaint, go back to check your prevention plan to say, does this plan need to be changed, having regard to what's been reported. This is because this is the workplace health and safety regulator that's responsible for this. If something occurs within your school and it becomes a work cover claim, you could imagine that work cover will be asking the question, how have you implemented your prevention plan? Give us evidence of that. The next thing I wanted to mention, as I mentioned, was the National Redress Scheme. So the National Redress Scheme, again, came out of the Royal Commission, and until now, generally only those schools that have been part of denominational bodies have joined the National Redress Scheme, but a large number of schools haven't. And the other schools that have gone in, obviously, are those that are part of state or government education. Now, applications, the scheme was set to run for 10 years. Applications can be made until 30 June 2027, with the scheme ending then. But there's still the likelihood that it would get extended. And from my experience in observing the scheme over the last 7 or so years, and seeing how the scheme has been amended in response to the various reviews that have been held by Parliament, my expectation is that it would be extended. So we have to prepare for the fact that this scheme will be extended. Now, the redress scheme, as I see, going on a bit of a recruitment drive with schools. Essentially, they're requiring any organisation to join if that organisation is named in a redress application. So if someone puts in a redress application and they name your school, the redress scheme will approach your school and invite you to join. Now, I say the word invite because it's not really an invitation. It's really a you must join. And the reason I say that is because even though when the redress scheme first was started, it was very much expressed to be voluntary, and I was involved in some of the roundtable conversations around it, and that it would be voluntary. But after it came in, there was a desire to encourage organisations to join, and in order to encourage them to join, the government said, well, we can have a stick through the ACNC and have the ACNC say that if you don't join, you're no longer existing for the public benefit as a not-for-profit entity. And so the ACNC established ACNC Governance Standard number 6. This was a new governance standard. Previously they only had 5. And this required charities to take reasonable steps to participate if they'd been named in an application. And they need to take reasonable steps to join within 6 months, and a failure to join may be then reported to the ACNC and could lead to revocation of charity registration. And of course, if you lose your charity registration, you'll lose your entitlement to government funding because you'll no longer be a charity and able to be endorsed as a non-government school. So what that means is that if you receive a request to join, you at that point need to be then taking those active steps to join. Having said that, you still want to be taking advice fairly promptly because you only have a 6-month period in which to go through the process and to join. Now, there have been some concerns raised around the National Redress Scheme. You might have seen in the media over the last few months around the National Redress Scheme and historical sexual abuse claims generally being used by organised crime and some significant fraud on the scheme. And so that is a continuing worry about the scheme and that it is being used for improper purposes. And so we need to continue to advocate to government that yes, this scheme is important, but it's also important that it's properly managed and that it's not being abused. Just want to then turn to privacy and cyber security and some of the changes that we've seen in this space. Cyber security has been a significant issue. I'm sure many of you would have been caught up in the Qantas data breach. I was caught up in the Qantas data breach. But the reality is that was talking about a data breach with some fairly mundane information, names, contact details, email addresses, mobile phone numbers, still fairly mundane. When you think about a data breach involving a school, you are talking about far more serious information. You think about the amount of information that you collect within your school, which is very sensitive, goes to the mental health and well-being of students, their disabilities and impairments and the like. And imagine what would occur if that information was the subject of a data breach. Government's done a number of things over the last 6 months particularly to require organisations to take a far more active role in managing their data. One of the first things they did applies to every Privacy Act entity, and so that's any entity that has a turnover of 3 million or more, so every school will come within that. Until now, those organisations, if they became aware of a cyber security attack and then were hit with a ransomware claim, and there has been a school that's had that, at least one publicly reported, they were able to pay that off through insurance and keep it all fairly quiet. Now the government has changed the law to say that yes, you can still make ransomware payments to protect your information if there has been a data breach, but you need to report the fact that you made that payment to the Australian Signals Directorate within 72 hours. And so that occurred from 30 May this year. Now the government's taking just an educative approach on that for the balance of this year, but then from next year it will be a regulatory and enforcement approach. Now the reason why they're doing this is twofold. Firstly, they want to be gathering information about what are the cybersecurity attacks that are happening, so that things are not just happening being pushed under the carpet. They want to be aware of where the risks are, and also that when they're aware of where the risks are, they can educate organisations about how to respond to those risks, how to strengthen themselves against becoming an unnecessary cybersecurity attack. And so there's just that importance to be aware that the cybersecurity profile is changing, and you do need to be taking active steps to protect your information. The next change that came about, and this one's probably even got more ramifications for organisations than that change, is that the government have introduced a new tort of privacy into the Privacy Act. We've never had a tort of privacy here in Australia. When I say a tort of privacy, I'm basically a right to sue because of a breach of privacy. We've never had that. You can make a complaint to the Privacy Commissioner, but we always used to regard the Privacy Commissioner as a bit of a toothless tiger. There wasn't that much that they would do. Now individuals can actually sue under the Privacy Act for a breach of privacy. And we've actually seen already Maurice Blackburn indicating that they're going to bring a class action against Qantas for that breach of privacy and that occurred in the last couple of weeks. As I said, schools have far higher levels of information than Qantas would have. So what happens here with this breach of privacy? First thing to say is only an individual can bring it, so an organisation can't bring a claim for a breach of privacy, but any natural person can. And what they've got to demonstrate is that they've had an invasion of their privacy. Now, the legislation talks about that either being an intrusion into their private space, recording of their private activities, or a misuse of their information. And so it's that third category that you would ordinarily have. CCTV could potentially come into the earlier category as well, but certainly the misuse of information. Secondly, that the plaintiff has a reasonable expectation of privacy. So they would reasonably expect that when they gave their information to you, particularly their sensitive information, that you would keep it private. And certainly the type of information that you collect as a school, they would have that reasonable expectation. Thirdly, that the invasion was intentional or reckless. Now, it's not really going to be intentional within a school context, but it very likely can be reckless. You haven't taken adequate steps to safeguard the information from exposure. And then thirdly, the invasion was serious. And again, seriousness is going to depend upon the content of the information, and the content of the information that schools collect, the type of information that you have. It is going to be serious if that is breached. And then finally, the public interest of the plaintiff's privacy outweighs any countervailing public interest. I can't see that ever really being an issue within a school context, because it will always outweigh the school's public interest. And the remedies include compensation. It includes compensation for harm, personal injury, as well as loss of economic loss. And so compensation orders can be quite significant. So what do we see with these reputation, there's privacy and cybersecurity changes? Well, firstly, the reputational and financial consequences are significant. And so that's why it's really important that schools are responding and are getting across what are your data security risks, what are your cyber security risks, and how you're going to manage those. So what I would ask you as a school is, how secure is your data, particularly your sensitive information, so that the records that you're taking from students and from parents around student impairments, counselling records and the like, now that everything is being stored online within a cloud environment, how secure is that data? The next thing you need to ask yourself is, do you need to keep the information that you are keeping? Is there really a requirement to keep that, and if so, for how long? I know that we've been saying for quite a while now that you want to keep as much information as you can for as long as you can, but you need to still ask that question, do we really need to keep it? Do we really need to have records of a student's impairment for 10 years? Are your staff regularly being trained regarding cybersecurity threats, given that they're probably the main chink in the armour when it comes to them receiving emails, clicking on links, and adverse actors being able to gain access to your systems? What about your CCTV cameras? Where are they placed? Are they accompanied by appropriate signage? Are they in appropriate spaces? Generally, the answer to that would be yes. I expect that when you have your CCTV cameras installed, you're usually getting advice from the company and you're getting signage from the company, but making sure that you are doing that. And then finally, make sure that you're reviewing your privacy policies in light of all of these amendments, and making sure that staff are aware of the expectations. Your privacy policy will be a part of all of your enrolment contracts, and so you're pushing it out to your parent community as part of that, but just making sure that you're keeping those under constant review. So there's some of the things that I've seen over the last few months, seeing over the next few months. A little bit different, but hopefully it's been of help. I'm not sure if we've really got time for questions. I think Chris is following me, so happy to speak to anyone afterwards.